Plenty. All right, I say we roll this thing on out. I need the bills we're doing. The agenda. Chandra, I need the agenda. It's so crazy. This thing, yeah, all this stuff. You know, Prince Charles did this because he got sick. So, Amen. Thank you. Dean, thank you. It's been so hard. Listen, he's the greatest guy ever. I can tell you, you work hard, man. You okay? I'm fine. Gloves and mask? Yeah. Good? You probably wanted to wear this for a long time around this crowd. I'm just waiting for you to. This is really weird. Out there. By the way, I just assumed I chaired you. Do you want a chair? That's right. Y'all just sit down. I forgot for a minute. All right, so we need a stick. Minutes. Discussion. Changes.
Same. No, 1038 is the appropriations bill. That's the same.
So which one?
It is actually not on here. No, actually, it's
Which one is the Jackson Whisper?
and then maybe have Erica remove changes for it.
Ready? The House Committee on Rules, Calendar, and Operation of the House will come to order. The chair welcomes our members and guests who are here today. Members, for your planning purposes, it's the chair's intent to take up the bills that came from the substantive policy committees, proposed committee substitutes that rolled out from them, and to go through them as far as what changes were offered. And then we will move into House Bill 1043, which is the sort of the omnibus bill. So with that, House Bill 1034, the small business emergency loans, Ms. Churchill or the appropriate staff, direct me, please, to explain any changes that came from or that came since the policy committee met.
Mr. Chair, this is Erica, and I believe there have been no changes to this one. This one is the bill as it was reported out of its policy committee, and Cindy Averett should be on the meeting to help with any questions.
Ms. Averett, if you're on, if there are any changes to House Bill 1034, the small business emergency loans, since it came from committee, would you please let us know that? Since the chair does not hear Ms. Averett chiming in with that beautiful Harnett County voice, we will move on to House Bill 1039, the COVID-19 Response Act Economic Support. Ms. Churchill or appropriate staff, what changes, if any, were made since this bill went through the appropriate policy committee?
Mr. Chair, as I understand, this likewise has had no changes since the last policy committee.
So members, to be clear, this bill has cleared the appropriate House Policy Committee without any policy changes. Therefore, the chair is going to move on to House Bill 1035, the Education Omnibus Bill. And Ms. Churchill, again, are there any changes since this left the appropriate House committee?
Mr. Chair, I believe there is a PCS before the committee, and Ms. McCraw should be on the committee, on the WebEx, to help with explain any of the changes.
Without objection, the proposed committee substitute to House Bill 1035 is before the committee. Seeing none, the proposed committee substitute to House Bill 1035 is before the committee. And Ms. McCraw or Representative Lambeth or whomever wishes to present the chair would ask that you only present the changes from the bill when it left the appropriate House committee. So who wants to go first?
Mr. Chair, unless Representative Horn or Representative Fraley would like to speak, I'm happy to review the changes for the committee.
Please do. You are so recognized.
So members of the committee, you have before you the PCS for House Bill 1035. I'm going to direct you to the sections that had changes. Section 3.6 is the first change. That deals with advanced math placement. So under the prior bill, local school administrative units had the authority to place students in advanced math. This change would allow students the opportunity, if they desired, to take a placement test for the opportunity to be placed in advanced math. So that is the change that was made in section 3.6. The next change is in section 3.9. There's a new section that provides for school calendar for the 2020-2021 school year. The first part of that section deals with development of remote instruction plans. Public school units will be required to develop plans for how to do remote instruction in the next school year and submit those plans to the state board. The next section then deals with the actual calendars for the 2020-2021 school year. School systems will have to provide 190 days of instruction, which include 5 remote instruction days that are in accordance with those plans. And the last subsection of that requires reporting on that to the Education Oversight Committee. Section 3.10 is the next new provision. This would provide for schools that are coming to the end of their school improvement plans that run on a 2-year cycle, a 6-month extension to complete development of those plans. They would have until the end of the calendar year, and their new plans would only operate for 18 months rather than 2 years. And then on section 3.11, the next new section actually correlates with House Bill 1038, which was the appropriations bill heard in House Appropriations this morning. That bill had a section in it on summer learning plans, and this provision actually extends the date for submission of those summer learning plans to June 22nd, 2020. And then the only other change is actually no longer in the bill. There was a section 12 that dealt with an issue related to children of wartime veteran scholarships, but additional information from the Department of Veterans Affairs indicated that change was not needed. And Mr. Chair, that is all the changes on this bill.
Members in the room and members online, are there any questions regarding the proposed committee substitute to House Bill 1035 as explained by our staff? If you could, when you could let me know if anybody seeks recognition. chair is aware of, the chair is aware of no person seeking to offer or to ask a question on the proposed committee substitute to House Bill 1035. And as such, we will move to House Bill 1037, which is the Healthcare Working Group Policy Recommendations. Are there any changes to this bill from what came out of the substantive House Committee?
Yes, sir. Mr. Chair, this is Teresa Matula.
Mr. Tully, you are recognized to explain the changes.
Thank you. Also, I believe Representative Lambeth is on. If he would like to go through the changes, I'm happy to.
Representative Lambeth, would you like to speak only to the changes to House Bill 1037 since it's left the Health Committee? If so, you are.
Thank you, Chairman. I am on here. We did have two changes since the Health Committee approved this yesterday. The first is neither of which are very significant in the scheme of our bill. The first, you will see under section 2.1. Let me make sure I got the right section. It just tightens up the language a little bit. Section 2.1A tightens up the language a little bit. And then in the haste to finish yesterday, Representative Sasser had two amendments. He had the wrong one approved and withdrew the right one. So this corrects an amendment that Representative Sasser had in the committee yesterday. The committee endorsed it, but he withdrew it, in error. So we've added it back. It's in section 4.1. No significant change, and it also was endorsed by the committee. The committee endorsed this as well as the funding bill, which is the next one. It was strong bipartisan support.
Members, are there any questions for Representative Lambeth or for staff on the committee substitute to House Bill 1037?
This is Representative Holly, and I want to do an amendment on that bill. If that's possible, when do I do that?
Representative Holly, the chair, appreciates the lady's input. It was the chair's intent to take amendments only on the bill that arrived or that we are dealing with, the Bell and Jackson Lewis bill. It was the chair's intent to take only the to deal with the bills as they came from the policy committees. So at this time, the chair does not believe the amendment would be in order.
So I'm not able to make an amendment on this bill all in committee. Just want to make sure I understand that. Can we do it on the floor?
Representative, the chair thanks the lady for her question. That will be up to the speaker. But again, the chair is not intent on taking amendments at this time, or frankly, has the amendment been provided to the chair?
Thank you.
Thank you. Are there further questions on the PCS for House Bill 1037? Seeing none, we will move to House Bill 1038, and Ms. Churchill or the appropriate staff is recognized to speak on this bill.
Not me. How 1038?
Mr. Chairman, this is Representative Lambeth again. I'll be glad to. There are no changes in this bill. This bill came out with unanimous support and went to appropriations, so there's no change in this bill.
So to be clear, House Bill 1038 is not a PCS. This is the exact bill that rolled out from the substantive House committee and therefore is before the committee at this time. Chair does not intend to accept any amendments on this bill. And so we will move now to House 1043. This is the Bell Jackson Lewis bill. And for members of the public that may be listening in, this bill has been heard through the speaker's working committee, but to get this on the record and so that members of the public can know exactly what we are taking up, the chair is going to recognize Ms. Churchill to go through a brief explanation of this 30-some page bill.
This is Erica. Would you like to go through the entire bill or just the changes from when it was last heard in the work continuity of state government working group?
I think in the interest of transparency, it'd be good to go through the entire bill, but as you are one of our more, as you have been involved with this bill since its inception, I think you will know what is relevant to spend more time on versus less time on, but I do think we should go through the entire bill.
Yes, sir. So first thing to note is there is no section 1 in this bill. As introduced, it contained a section 1 that dealt with some issues that AOC has already resolved via order regarding Rule 5 service. AOC requested section 1 to be removed. It has been in the PCS. So we start with section 2, which is a new authorization to allow emergency video notarization under certain circumstances that would allow a notary to conduct the physical proximity requirement via audio-video conference. Section 3 is similarly emergency video witnessing to allow someone to be sworn. Section 4 is regarding, right now it is illegal for someone to wear a mask over their face. It's less specifically allowed. The current law does not specifically allow wearing a mask for the purpose of the physical health or safety of the wearer or others. Section 4 would allow that, but would require the person wearing a mask for the purpose of ensuring physical health or safety of the wearer or others to remove that mask upon the request of any law enforcement officer. Section 4.5 would clarify that electronic signatures for search warrants and certain court orders that follow those court hearings can be done electronically. Right now, it's a little unclear in the law. This section would expire August 1st, 2020. Section 4.7 would allow the chairman of the ABC Commission to temporarily allow some certain mixed beverages, provided that it is accompanying salt with food. Also would expire upon the expiration or rescission of Executive Order 116. Section 4.8 would allow a little bit of an extension to claim lottery prizes that are either expiring or awarded between March 10th, 2020 and August 1st, 2020, would allow the claimant an extra 90 days to submit to the Lottery Commission in writing. Section 5 would extend the validity of credentials issued by DMV for up to August 1st, 2020. Section 6 would allow for the online renewal of a special identification card, which is not currently authorized. Section 7 would delay the DMV headquarters move so that it needed to begin on October 1st, 2020, rather than be completed by October 1st, 2020. Section 8 would allow for advanced healthcare directives, which currently require a notary and 2 witnesses to be executed between now and August 1st with 2 witnesses or a notary. Section 9 would provide for service and notice of a petition for an adult guardianship hearing in the temporary time between now and August 1st. If the respondent resides in a long-term care facility that is restricted visitors, the petition could be left with the employees of that facility. The employee would then in turn be required to deliver the petition to the respondent. The proof of service would indicate with whom it was left. Section 10 would between now and August 1st, temporarily allow for the disbursement of funds prior to the recording of a deed in certain circumstances. Section 11, between now and August 1st, would extend the life of a marriage license to 120 days and also allow the applicants to apply via audio-video communication rather than in person before the Register of Deeds. Section 12.5 would allow for the administration of the oath of office for new attorneys to be done via audio-video conference rather than in person. This would expire December 1st, 2020. Section 13 would delay the school capital outlay report due from the local government commission. It's currently due on Friday, May 1st. It would delay that date to July 1st, 2020. Section 13.5, beginning on June 30th of this year, would allow a carry forward for 1 year of the driver's education funds that are unexpended and unencumbered at the end of this year to not revert. Section 14 would temporarily allow for the governing body of a city or county to establish an expedited process for training and designating personnel other than law enforcement officers to obtain custody and transportation of persons for involuntary commitments. Section 15 would allow for the hearings for involuntary commitments and the medical examinations involved in those commitment hearings to be done via telemedicine between now and August 1st, 2020. Section 16 would expand the reasons that communicable disease information may be shared by the Department of Health and Human Services or the local health department to include law enforcement for the purposes of preventing or lessening a serious or imminent threat to the health or safety of a person or the public, to enforce the public health communicable disease statutes, or to investigate a terrorist incident. The law enforcement officer receiving that information would be required to maintain its confidentiality. Section 16.2 would allow licensed soil scientists to evaluate, inspect, and approve on-site wastewater system projects between now and August 1st. If the project is begun prior to August 1st, the soil and scientists could continue that project to its completion. Section 16.3 would allow the Department of Environmental Quality to establish emergency measures to allow for yard waste to be in the landfill temporarily between now and August 1st. Section 17 would expand who may be appointed a medical examiner to include retired physicians. Section 19 would provide that the state health plan premium and debt payment could be deferred beyond 30 days. Given a disaster or other event. Section 20 would allow for interim determinations of certain disability benefits without a meeting of the board, but during this event expiring August 1st. Whatever the decision was could be appealable, but would never require any refund. Section 21 would temporarily allow for the teachers in state employment retirement system retirees to return to work within 1 month rather than 6 months if it was COVID related. Section 21.2 would extend the validity of a probationary certificate issued by the qualifications board for any building code inspector. If it was set to expire, the probationary certificate was set to expire between March 10th, 2020 and March 10th, 2021, it would be deemed valid until March 12th, 2021. Section 21.3 would allow any state agency to waive interest due on a past due account receivable involving procurement. Section does not apply to the University of North Carolina healthcare system or to East Carolina's Division of Health Sciences for healthcare services, to the Turnpike Authority for money owed to it, or to the North Carolina State Health Plan. Section 22 would allow that for the rescheduling of a public hearing during temporary rulemaking. Right now, similar authority exists for permanent rulemaking and emergency rulemaking, but not for temporary. Section 23 would authorize the chief administrative law judge to extend the time period for the filing of a contested case. Section 23.5 would clarify that in the local government budget process, the budget that has to be presented in the office of the clerk and available for public inspection could be done via the website of the unit of local government between now and August 1st, 2020, rather than requiring the office of the clerk to be open with someone in it for those types of requests. Section 24 would allow the secretary of the local government commission during a declaration of emergency to change the daily deposit requirement, either in terms of the amount of cash requiring that daily deposit or to something more than a daily requirement. It would have to be at least weekly. Section 25 would reinstate some special obligation bond authority that was inadvertently repealed in 2019. Section 26 would extend the effective date of the new combined land use planning for counties and cities, known as Chapter 160D. Right now, it's set to become effective January 1st, 2020. This would extend that to August 1st, 2021. Section 26.1 would take one provision out of the new proposed Chapter 160D and apply it immediately, but set to expire on August 1st, 2021, when Chapter 160D becomes effective, allowing local governments to incorporate by reference any federal flood insurance rate maps, watershed boundary maps, or other maps as adopted or promulgated by the state or federal agencies. The local ordinance could say that the local ordinance automatically updates to reflect any map changes. Section 27 would specifically authorize remote meetings, up to and including every member of a public body meeting remotely during a declaration of emergency in which the governor has restricted the number of individuals that may gather in one place in order to protect the public and the public health. Section 28 would extend the time period for local governments to report their ordinances that contain criminal provisions to March 1st, 2021. Section 29.1 would extend the life of the North Carolina Child Wellbeing Transformation Council, currently set to expire on June 30th to January 15th of next year. Section 29.2 would delay the effective date of the requirement for transportation network companies to have on their cars certain signage, currently set to become effective July 1st of this year. This would delay that to July 1st of 2021. Section 29.3 would extend the life of the Joint Legislative Study Committee on Small Business Retirement Options until December 1st of this year. It expired March 31st. Section 30 would authorize state agencies to exercise certain regulatory flexibility during this event to delay the collection or modify the method of collection of any fees, fines, or late payments, to delay the renewal dates of permits, licenses, and other similar certifications, registrations, or any authorizations issued by that agency, or to delay or modify any educational or examination requirements implemented by that agency. Any such changes would need to be reported to OAH for the North Carolina Register for recording. This section would not apply to the Division of Employment Security Commission, the Department of Health and Human Services, the State Board of Education, the Department of Public Instruction, the University of North Carolina, the State Board of Community Colleges, or the State Board of Elections. Section 30.1 within the Department of Health and Human Services is the forensics test for alcohol branch that does some certification and licensure for law enforcement officers administering DWI tests. This would allow them to extend any certifications already issued if the educational or examination requirements are delayed. It's effective March 10th of this year and expires January 1st of next year. Section 30.2 would extend the life of certain local government permits. The permit would have had to have been in effect on April 28, 2020, and it would extend the life of that permit for 5 months until September 28, 2020. Section 30.5 would clarify how to modify any court order for intermittent punishment. Typically, this would be a DWI court order that requires reporting for weekend jail time. This would simply allow for the DA to consent to the modification and the Chief District Court judge to modify that order. Section 30.6 would change for 1 year the cash floor for DOT to $125 million. Section 30.7 would say that in administering FEMA public assistance or individual assistance funds, the North Carolina Department of Emergency Management can utilize the North Carolina Regional Council of Governments. Section 31 is the severability clause, and Section 32 is our standard effective date, or effective when it becomes law, unless otherwise said.
Thank you, Ms. Churchill. Members, are there questions for Ms. Churchill on House Bill 1043?
I have a question, Representative Lewis. This is Representative Adcock.
Representative Adcock, the lady is recognized to propose a question.
Thank you very much. Just a background question. I'm making an assumption that all of the changes and adjustments made to agencies were either at their request or at least they reviewed them and they're okay with them. I'm assuming that's true, but I just want to make sure.
Ms. Churchill, are you able to respond to that from Representative Adcock?
Representative Adcock, the agencies have been asking for multiple things. Hopefully the language, I can't promise you since this was finished up at 2:21 this afternoon, that every agency has seen every word, but hopefully they will let us know if they have any issues with the exact wording. But I believe all of the items listed, they have been involved in.
Follow up?
Representative Adcock, the chair would add that we have made every effort to not only make this a bipartisan bill in the chamber, but also to reach out to the executive branch as well. But the lady is recognized for a follow-up.
I appreciate that, Representative Lewis. I was only going to add that if anything was inadvertently not worded just right, we can fix it on the floor, can't we?
Yes, ma'am. That is in fact correct, or it can be done in the conference bill. Are there further questions on this bill?
Chairman Lewis, this is Representative Torbett.
For what purpose does the gentleman from Gaston seek recognition?
I'd like to ask a question about House Bill 1043, sir.
The gentleman is recognized for that purpose.
Thank you. I was listening intently, but I might have missed one portion. Was there anything mentioned about curbside delivery of alcoholic beverages being added to this bill?
Representative Torbett, the chair apologizes to the gentleman. The chair did not hear what you asked, sir.
I'm sorry, I'll repeat. Thank you, Chairman. I heard something about alcoholic beverages, I believe. Was that a curbside delivery of alcoholic beverages from retail establishments, or did I not hear that?
Ms. Churchill, the chair believes the gentleman is asking about alcoholic beverages. Could you speak to that point in this bill?
Yes, Mr. Chair, it's page 6, section 4.7, and it would allow for alcoholic beverages up to 2 servings per meal or food item ordered to be connected with your takeout.
Follow up, Mr. Chairman.
The gentleman is so recognized.
I'm deeply concerned by that. I do understand that the negative impact that the closure executive order has put on records and constraints, but I'm deeply concerned that this does a couple of things. One, it provides access to an open container in an automobile. It also provides better access to drinking and driving. It also provides access for minors in a vehicle if those 2 drinks are in the vehicle. I'd be all supportive of consumption on the property, similar to what they do now when they are open and have outside dining. But to be able to take 2 mixed drinks, if there's 2 people, that's 4 in a car driving home. I'm deeply concerned about what we're doing with this action, Mr. Chairman. I just wanted to express that. And on behalf of Representative Hurley too, she asked, and she's not on the committee, to also express her deep concerns on what it might do to the impact to marital issues at home, as well as child safety. Thank you, Mr. Chairman.
Thank you, Representative. The chair will recognize Representative Bell to respond to that.
Thank you, Mr. Chairman. Representative Torbett, all the current laws still apply. These will have to be sealed, and but all the current laws are applied. They're open containers in the vehicle when they get pulled over. All current laws apply. It's actually no different than what's been done right now with beer and wine.
Thank you for that explanation, Mr. Chairman.
The chair would also point out that this came came at the request of the chairs of the House ABC Committee, and is consistent with all of the safety requirements in terms of preventing underage people from having access to this, and preventing, to the extent it can, overconsumption as well.
Thank you, Mr. Chairman. I just felt like I had to bring that out to the purview of the committee. Thank you.
Are there further inquiries on House Bill 1043?
This is Representative Quick.
The gentleman is recognized for an inquiry.
Mr. Chair, I actually just wanted to state similar concerns as Representative Torbett about that provision, notwithstanding the fact that Representative Bell has just told us that the laws will still apply. I definitely wanted to just chime in and say that I have very similar concerns to Representative Torbett, and just that frightens me a little bit that we would head in that direction.
Are there further inquiries on this bill or
Mr. Chairman, this is Representative Torbett. I'm sorry to bother you again, but are we moving into an amendment process? I had an amendment to offer.
Yes, sir. In just a moment, the chair wanted to deal with any questions on this bill as it stands, and then we'll move into the amendment process.
Thank you very much.
Mr. Chair.
The chair,
Reeves.
Representative Reeves, for a question. The gentleman is recognized.
Question, Ms. Churchill. I want to go back to the mask section, and specifically page 7, lines 1 through 3. In the case of a traffic stop or checkpoint or roadblock, isn't it already law, if I'm reading the entire section, unamended section correctly, isn't it already law that a person would have to remove their mask during that traffic stop?
Representative Reeves, the chair is going to direct that to Ms. Churchill. Loves to participate in these committee meetings.
Representative Reeves, I'm going to give this a shot, and I feel confident that my colleagues will alert me if I'm saying this wrong. First of all, I think the PCS, this is actually on page 5 and page 6. So the language may be a little bit different from the version you're looking at.
Good. I'm having a hard time bringing up the version I want to see, so thank you for that. But go ahead.
As I understand it, the requirement to remove for a traffic stop is if you're wearing that mask when operating a motorcycle. So the new language at the top of page 6 of the PCS, which is CSST FP-68, should be available on the House Rules website. It's lines 1 and 2 of page 6, and I will read. A person wearing a mask for the purpose of ensuring the physical health or safety of the wearer or others shall remove the mask upon the request of a law enforcement officer. So this language would not require a traffic stop to be involved. It would simply be that a law enforcement officer asks for the mask to be removed.
So follow up, Mr.
The gentleman is so recognized.
So if I'm understanding that correctly, then in the PCS, gentleman's walking down the street, officer comes up and says, hey, I need you to move that mask. That's really it. There's no need for any reason for it. You can just go up and ask for removal of the mask. Is that correct?
Yes, sir. As drafted, I believe so.
Okay, so that actually broadens the language that was originally in the bill.
In the bill as filed, yes, sir.
All right.
To be clear, though, before we proceed, Representative Reeves, to be clear, it's currently against the law in North Carolina to wear a mask. So the bill was an attempt to broaden that, but the gentleman is recognized for a further inquiry.
Thank you, Mr. Chair. And actually, that was what I commended the sponsors for allowing that in, because I know that in earlier committee meetings, that was a big discussion. And I remember the issue coming up about what happens with law enforcement. I guess my point was, once you include it in the number of exceptions that we already have in the bill, it seems like that's still getting treated just a little bit differently, if I understand correctly, than the other exceptions in the bill. So that was my concern, but I know this is just a time for questions, so I'll save that discussion and comment for a later point. But thank you, Mr. Chair, for that. And thank you, Erica.
Members, are there further inquiries on the bill before we move into amendments? Chair sees no members seeking recognition, so we'll move into amendments, and Representative Torbett is recognized to send forward an amendment, and to staff, the chair would like a copy of that if possible.
Thank you, Mr. Chairman. Let me know when you receive a copy and I'll be ready to go.
Okay, so apparently the chair has the only copy of this. This is from Representative Torbett. It deals with the DOT emergency reserve clarifications and modifications. Let's be at ease. Is this on the screen yet? Can the public see this yet?
Yes, sir.
All right. So just to be clear, can staff provide direction to the chair as far as page and line so that the folks can follow along? Okay, so this amendment, if adopted, would be rolled into the appropriate place as far as page and line. So with that, Representative Torbett, the gentleman from Gaston, is recognized to explain his amendment.
Thank you, Mr. Chairman. As the department's financial circumstances have been greatly diminished with revenue losses caused by the pandemic, it needs the flexibility to provide by these changes. The amendment does not increase appropriations, but does give needed flexibility in how DOT uses existing funds. The ability for DOT to use the $64 million placed into the emergency revenue reserve from State Law 2019-251 to pay for expenses from past storms would add to cash availability, freeing up that amount for other uses. The current language says it can only be used for future storms. Clarifying that emergency funds are for reimbursed expenses only ensures we don't jeopardize any federal disaster reimbursement. We don't want federal agencies to see the state has money set aside and reduce reimbursements as a result of that set aside. We asked that a later requirement from State Law 2019-251 to place $125 million into the new emergency reserve for 1 year because yes, sir.
Well, Representative Torbett, if the gentleman would suspend for just a moment, we're having a small issue with the staff as far as the correct version being before the chair. And this is to be expected using virtual conferencing and things like that. If the gentleman would just suspend for a short time and let staff get the correct amendment before the chair and make sure that the gentlemen, the members, and the public have access to it as well. Chair.
Absolutely. Chairman, I have V4.
Thank you, sir. So we're going to suspend the conversation on the Torbett amendment. Actually, we're going to return the Torbett amendment to the gentleman as it's not the correct one. The chair will ask staff to assist the chair. The chair understands that Representative Holly may have an amendment and there may be others, but unfortunately they're not at the dais. So is staff in possession of any other amendments at this time? All right, for members, for ladies and gentlemen of the public who may be listening, this is probably a frustrating thing to come to a pause, but that's what this is. There are times when this committee or the chamber has to pause and be at ease in order to make sure that the matters before the committee are correct. So with that, the committee is in session, but we'll stand at ease for just a moment to make sure we get the amendments that members wish to offer before the committee.
Send me a message.
Hopefully getting on the. I forgot to call the roll, so we'll do that in a minute. Hey, Darren.
David. David, Representative Floyd.
Representative Floyd, for what purpose does the gentleman seek recognition?
I was going to ask you if you could mute your mic while you was in conversation.
The chair apologizes, Representative Floyd. I didn't hear what you said, sir. The chair will say that the chair has no ability to mute the chair's mic. So the chair may be the one that's causing the problem. The chair apologizes. The chair would also say that the chair's been advised that Representative Holly was going to offer an amendment. The staff may not be aware of that, but please look. It may have been submitted originally by Representative Richardson. We need to get that for the chair if we can before we proceed.
That's for House Bill, excuse me, Mr. Chair, for House Bill 1037.
Yes, ma'am. Members, so that you can be prepared, while it was not the chair's original intent, Representative Holly has as staff to prepare an amendment for House Bill 1037. And the committee will be taking that up as soon as it is prepared by staff. We're also waiting on the correct Torbit amendment, and all right, so we're going to go back to Representative Torbit, who has proposed an amendment to House Bill 1043. Representative Torbit, the gentleman from Gaston, is recognized to explain his amendment.
Thank you, Mr. Chairman. I'll finish up real briefly. Is that we also, inside of this, we asked to delay the requirement from State Law 2019-251 to place $125 million into the new emergency reserve for 1 year because we simply don't have the funds to set aside that amount. When DOT drops below the cash floor, which it has, it cannot enter into new contracts included for projects funded by bonds and grants. Since those funds are not affected by the cash balance, we'd like to be able to proceed with such projects to reduce the economic impacts on our industry partners, which is the jobs that are out in every district throughout North Carolina. Also, the department wants to be able to respond to any upcoming disaster needs, even when operating below the spending cap. Thank you, and that's the purpose of the amendment. Sorry, it was late in coming, but as you know, and I know, everything is extremely highly volatile and highly fluid at this point.
Members, the matter before the committee is the amendment sent forward by Representative Torbit. Staff is doing their best to scroll it onto the screens. If there are questions on this amendment, inquiries to the amendment sponsor, that would be appropriate at this time. And then we'll move into debate on the amendment itself. Is there any member that wishes to ask a question or propose an inquiry to Representative Torbit? The chair has been advised that Representative Stevens has an inquiry to Representative Torbit. Representative Stevens is recognized to propose that inquiry.
Thank you, Mr. Chair. I understood him to say the 125,000 basically had already been appropriated. But is there not a new appropriation under the 36,000? Or is that money that's already been appropriated as well?
Mr. Chair, if I may respond, that's the existing language. Only those items that are underlined is what we're actually changing in the bill. That was in existing language from last year.
Representative Stevens, does that answer your question, ma'am?
Yes, it does.
Are there further questions to Representative Torbit? If not, we'll move into debate on the amendment. Would any member like to speak on this amendment? The chair is aware of no member wishing to speak on this amendment. Therefore, the question before the committee is the adoption of the amendment sent forward by Representative Torbit. Those favoring the adoption of the amendment will say aye.
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 Aye. Aye.
Those opposed will say no. In the opinion of the chair, the ayes have it. The ayes do have it, and the amendment is adopted.
Thank you, Mr. Chairman and members of the committee.
Members and ladies and gentlemen of the public who may be listening in, the chair is awaiting one additional amendment that he has been advised is going to arrive. We will stand at ease momentarily as we wait for that. Chair realizes that as you're listening in, this is an extremely frustrating process, but we want to make sure we get this right. So our staff is working diligently to prepare the amendment, and we will consider it when it arrives. Until that time, though, the committee will stand at ease. Without objection, Rule 12H is suspended, and Representative Jackson may take off his suit coat. As we're at ease, the chair would point out his appreciation to Bill Moore, David Layton, and our House Sergeant at Arms, Marlon Shepard, for their works and their attention to helping us conduct this meeting. I appreciate you guys. I know. Let's
Thank you. I thought I was having a.
Members, if the committee could come back to order, the chair apologizes for a breach in protocol. The chair should have recognized our committee clerk to call the roll, and therefore the committee clerk is at this point recognized to call the roll.
Thank you, Mr. Chair. Uh, The members I have present are Representative Adcock, Baker, Barnes, Beasley, Bowles, Bumgarner, Carney, Davis Jr., Dixon, Floyd, Fraley, Grange, Hardister, Hastings, Holly, Jackson, Quick, Reeves, Ross, Sane, Willingham, Ray, Soka, Torbett, Stevens, and Bell. If I did not call your name, if you will send me a message, that would be great, and I will list you as being here.
Actually, the chair will say, if you're a member of this committee and your name wasn't called, would you seek recognition now and let your name be heard? Madam Clerk, did you get the chair as president as well?
Yes.
So for members and ladies and gentlemen that may be listening in to this broadcast, we are still awaiting an amendment. This is actually a pretty normal legislative process. So please be patient with us as we get that. And but to the best of the chair's knowledge, there's only one amendment to be considered, and as soon as it arrives, we will recognize the amendment sponsor to explain it. We will debate it, and we will vote. After that, we will move these bills forward. So the committee will continue to stand at ease. Members and ladies and gentlemen, before we proceed, the chair was also neglect in the start of this meeting to offer his sincere thanks to our Sergeant at Arms staff and our central staff for their work, our committee clerks who continue to work today. Please know that your contribution is not unnoticed. We greatly appreciate you. Members, at this time, we're going to move into an amendment sent forward by Representative Holly. This is amendment, the code on it is H1037-ABC-120 version 1. It says that Representative Holly moves to amend the bill on page 8, lines 37 and 39 by deleting those lines. That amendment is properly sent forward, and Representative Holly is recognized to debate the amendment.
Thank you, Mr. Chair. Thank you for taking that few minutes to make sure that that amendment was able to come in. The first part of this amendment is to delete Section 8C. The feeling on deleting Section 8C is basically saying that we don't want to give every carte blanche. If you're working with the virus, we understand that you might liability, but what we don't want to give somebody who's not working with the virus to get off the hook for liability for what they do that's not representative. If somebody's doing knee surgery, they should not be part of this. And I think it was just worded to a point that it was a little too broad, that we need to treat patients with the virus, and that's what this is should be done. The second part is to eliminate the opportunity for somebody who is understaffed purposely to and maybe not getting equipment to keep that way without making an effort. We need to make sure that healthcare professionals, if they are aware of a staffing shortage, that they make every effort to get that staffing corrected. If they are in need of equipment, they need to make every effort to try to get the ventilators or whatever equipment that is needed in the bill. It's just important that we cover this. This bill covers things that are directly related to the virus and does not extend beyond other healthcare liabilities.
Thank you, ma'am. At this time, the committee will stand at ease. Members will return to order. The chair's been advised that Representative Adcock has a process question, and for that purpose, the lady is recognized.
Thank you so much, Mr. Chair. So I had a question, and please help me if I misunderstood something. So yesterday, when we got the email from your office about what was on the table to be discussed today, my understanding was the only bill that could be amended in committee today was House Bill 1043 that came, COVID-19 time-sensitive matters, and that we wouldn't be allowed to amend the other bills because I had an amendment I was going to run. And so can you help me with that, please?
Yes, ma'am. The chair appreciates the lady's question and also recognizes the lady's frustration. Chair would point out that in my conversation with staff, while we could have run this as an amendment to House Bill 43, it seemed to make more sense and was easier to follow as an amendment to House Bill 1037. If the chair erred in that, then the chair will offer, I do offer my apology. Certainly, we could have asked staff to word this in such a way that it would apply to House Bill 1043. I simply made the call that it would make it easier for the members of the committee and also the public that may be trying to follow it to be able to refer to House Bill 1037. So, and the final thing the chair would offer is the amendment would read something like, if House Bill 1037 becomes law, then the following provision is changed. So Chair apologizes for a change in course. Again, it was done with the idea that it would be easier to follow. If the lady is genuinely concerned about this, the chair will reject this and ask staff to prepare an amendment to House Bill 1043.
Follow up?
Lady is so recognized.
No, sir, I'm not asking for you to do that. I just wanted to understand the process, and for those of us who told staff not to bother to create an amendment for us, do you have some advice?
Yes, ma'am. The chair actually appreciates the question. Please understand that this is round one of the COVID response and certainly not even really the start of the session. So ideas will be discussed for the next few months and implemented into law. So the chair apologizes to the committee if this is because this is inconsistent with what the chair had said earlier. You try to skirt the line between making sure folks know what they're actually voting on and sometimes what the actual bill numbers are and whatnot.
Last follow-up.
The lady is so recognized.
I just wanted to say, Representative Lewis, nobody can criticize you for how you're conducting this meeting. This is a very tough place we're in. I think you're doing the best job anybody could do, and I appreciate your answering my question.
The chair thanks the lady, Representative Jackson, for a question or a comment. The gentleman is recognized.
Thank you, Mr. Chairman. Just for a comment and Representative Adcott's question, I just wanted to follow up and say that what the chairman's ruling is totally consistent with what was discussed yesterday. I had a discussion with the rules chair's office and the speaker's office, and we agreed that to this provision that the only bill that would be able to be amended in committee would be 1043 in rules today, with the exception of this language. And the reason for that is the advocates on both sides of this issue were trying to come to a consensus. And so I wanted to maintain the ability that if they were able to reach a consensus, that we would be able to put that consensus language in here today. And so it was known by all the chairs that this type of language might be presented in rules today, but nothing else would be allowed. This is not the consensus language. I want to make that clear. This language appears to be new language and not the language that the parties have been negotiating, at least not in the last draft that I've seen. I hope they'll continue to try to work this out and maybe we can get it fixed in conference.
The chair thinks the gentleman from Wake, Representative Soka, is recognized for a question or a comment.
Question for Representative Holly, then a comment. I just wanted to make sure that I understood your example, Representative Holly, the example that you gave of a knee surgery, and because they're not working directly with COVID-19 patients, that they could then be held liable for a patient under knee surgery getting COVID-19. Did I correctly understand you?
No. What I'm saying is that these rules should be restricted to people who are dealing with COVID-19 patients. So we shouldn't just give a blanket order to all doctors that anything that happens now during the emergency, they're not liable for. This is to be too restricted to just the COVID-19 situation and not just open up a can of worms for all kinds of surgery and all kinds of activities like that.
For a comment, Mr. Chair.
The gentleman from Cumberland is recognized.
Thank you, Mr. Chair. I better understand what your intent is, but I'm still uncomfortable with the intent and the language. It was interesting to hear Representative Jackson say that this is trying to be worked out. I'm glad to hear that, because at this point in time, I'm afraid I'll have to vote against this. Thank you.
Mr. Chair, if I could help a little bit on that question.
The chair believes that's Representative, and if it is, the gentleman is recognized to comment on the amendment.
Thank you, Mr. Chair. And what I would say, members, to kind of help this a little more succinct, this particular language started with the greatest of intentions, and an intention I completely agree with. And the original language in the bill was intended to protect our doctors. Right now, we don't know how to treat COVID. And right now, we're under emergency circumstances. So anything else that we do, we have problems with because of the COVID virus. We specifically wanted to make sure that we're protecting people who are on the front lines and treating people during this time of COVID. There's no ifs, ands, or buts about it. The last thing you want is for somebody to come in and be able to sue and say, well, now 2 years later, we figured out that had you done this, then you could have treated my COVID better, or my family member wouldn't have passed or anything like that. There's no issue there. What I think the problem that is developed with the language that ended up in the bill, and what I think Representative Holly, and I'm not trying to speak for her, but the way I read her amendment, what she's trying to do is the way this is drawn. I think that what you're doing is you're kind of opening up a circumstance that nobody intends. Because, for instance, if I were in a circumstance where I were defending as a medical provider during this time, when we look at section lines 37 through 39, which she's asking to be deleted, there is no circumstance outside of gross negligence where you would then be able to sue a medical provider for anything that they've done. So think of it like this. I'm a dentist. And so I decide that, or an oral surgeon, rather, dentist is not fair, oral surgeon. And so I decide, well, I'm gonna go ahead and do this surgery at this time on this person's teeth. It's not necessarily something they've got to have right now, but we've chosen to go ahead and do it. Because of the way we've written the language in this particular bill, whatever negligence that they normally would be responsible for is gone out the window, because generally everything has changed because of the fact that we're treating the COVID, because we have the COVID virus. And I don't think that's what anybody's intention is. I think what we want to do is we want to protect healthcare providers that are dealing with people that are dealing with the virus. What we're not trying to do is protect healthcare providers who have made decisions to go ahead and do other surgeries and cause injuries that have nothing to do with the COVID virus. So if they, for instance, they're doing the knee surgery or they're doing the oral surgery and they make a mistake that has nothing to do with the virus because of the fact that they were in a particular circumstance because of the virus, then we're stuck at that point. And so that's what she's trying to address, the 37 through 39. And I think that is very consistent with what healthcare providers originally wanted for protection. And I would ask that people support the amendment, because I think we just don't want to put things in a situation where people can make decisions at any point. You've got to make a decision as a healthcare provider right now about certain medical services. Treating the COVID virus, no decision. They're in it and they're doing it, and we appreciate what they're doing. Doing some of these other surgeries, I think there still has to be a standard of care that they're held to, and that's problematic. And the second part, and I apologize for being so long, Mr. Chair, and I appreciate your indulgence. The second part is simply that we don't want, especially since we've had such an outbreak at these nursing home facilities and things of that sort, we've still got to have a standard where people understand that you've still got to make the basic decisions to help protect these people. So again, we're not trying to open up nursing homes to negligence that has to do with some virus, that has to do with somebody, not being with the virus. But what we're doing is we're talking about, hey, you're not protected if you make poor decisions that have nothing to do with the virus, but have to do with you making maybe a financial decision that you don't want to have extra workers here today. That may be with, just a decision about you wanting to downgrade. Well, that's not because you didn't have a negligence problem because you were treating the virus. You just made a decision that caused people to be exposed to some type of injury they normally wouldn't have been exposed to. So that's a long way of saying we'd appreciate your support for the amendment. I do not think this amendment at all takes away any protections for anybody that is trying to help us through this crisis, but it does still hold a small standard for people who have made decisions that have nothing to do with this virus, and unfortunately at times maybe bad actors. Thank you.
Representative Bell, for a comment or a question, the gentleman is recognized.
Thank you, Mr. Chair. Members, there's been ongoing negotiations and talks with stakeholders about this section, and my fear is that if this amendment passes, we're going to upset that, and we're going to have even more issues than what we had. If this amendment stays and gets voted on, it will actually be the first amendment this committee has taken up where we have a non-unanimous vote. We've all worked together on this. We've all tried to work in a bipartisan and fair fashion. We are very aware that this process is nowhere near over. Even this bill itself still has to go through floor and Senate and in conference, and still a ways to go. And I would respectfully ask that the member withdraw the amendment, and good knowing that stakeholders are working on this, so we can keep that spirit. If not, we're going to have a contentious amendment, voted up or down on a bill that all of us want. So, Mr. Chair, I'd make that recommendation, but it's up to the member to do it. I'd ask that you not support the amendment if it does come forward.
Mr. Chairman.
Representative
Holly.
Representative Holly, the lady is recognized.
Thank you very much, and I appreciate the candid discussion. But there's still people's personal responsibilities are at stake, and we need to, if we know up front that we want to limit this only to incidences surrounding the virus, we're opening up a can of worms across the state by not passing this amendment. This amendment is critical to the average person who just happens to be in the hospital and something happens to them at that time that's not even related to the virus. It takes back their personal protection of what they can do and holds the hospitals, the doctors, and everybody harmless in whatever that happens during this period of time. And I don't think that's the intentions of the original bill. And I think the amendment should stand and we should pass it forth.
Representative Adcock is recognized for a question or a comment.
Thank you, Mr. Chair. I appreciate the spirit in which Representative Holly is offering this amendment, but I'd like to point out two things. The first is that, according to Representative Jackson, there are groups who are working on consensus language, and I want to respect that process. They are working on this, and I think that we should defer to them, knowing that we do have time for as perfect as possible language to be placed into this bill. The second I would just say is, as a healthcare provider, as a family nurse practitioner in primary care, who is triaging, screening, testing, and treating people for COVID-19, this is a situation in which best practices are changing day to day. And that has to be considered, the conversations that are being held about the consensus language. If this amendment is going to have a vote today, I would ask the members to please vote against it, not against Representative Holly, but in favor of the process that's being used to forge consensus language that Representative Jackson spoke of. Thank you very much.
Mr. Chair, this is Representative Holly. I will withdraw the amendment and let the process and let it work out. I think that everybody has heard what the concerns are, and that it will be dealt with in a consensus basis. So I withdraw the amendment.
Per the request of the sponsor of the amendment, will be returned to the lady. Representative Committee will be at ease. Members, the chair has been advised that Representative Reeves has submitted an amendment. We're trying to get that up on the screen for members to see, but in the interest of transparency, the chair is going to read it. It's H1043-AST-100 version 1. Representative Reeves moves to amend the bill on page 6, lines 1 through 2 by rewriting those lines to read, a person wearing a mask for the purpose of ensuring the physical health or safety of the wearer or others shall remove the mask upon request of a law enforcement officer during a traffic stop, including a checkpoint or roadblock under GS 20-1. Chair apologizes, under GS 20-16.3A, or when approached by a law enforcement officer. Representative Reeves is recognized to debate his amendment.
And thank you, Mr. Chair. And I apologize. We were trying to get this together kind of quickly. I actually meant for the amendment not to have the last 1, 2, 3, 4, 5, 6, 7, 8, 9 words and to stop at 20-16.3A. And I apologize for sending that in, because otherwise I'm thinking this just mirrors what we've already looked at. And I was trying not to quite mirror that. And if we could allow me to do that orally right now, then I'd be happy to discuss the amendment.
So Representative Reeves has asked without objection that a perfecting amendment be submitted on line 5 of this amendment, that the amendment would essentially end after 16.3A. So it would be to strike or when approached by a law enforcement officer. Is there any objection to the gentleman's request? Hearing none, the chair is going to consider that a perfecting amendment adopted by consent. And Representative Reeves, on your modified amendment, does the gentleman wish to offer further comment?
I do, Mr. Chair, and thank you. And members, on this one, if you look at the PCS that we've gotten, what I've done is try to mirror the other circumstances where we have exceptions with masks. I think that, in my opinion, I would still say that once we say that you can wear a mask for physical health or safety, that law enforcement is completely protected and completely within their rights during a traffic stop or checkpoint to ask that person to remove their mask. I don't believe we actually even need extra language for that. But in the spirit of trying to stick with some of the arguments that I heard from Representative Smith when he was accentuating this point during committee discussions, and also some of the concerns that I think law enforcement would have to make sure that they explicitly have the right. This gives you the right as a law enforcement officer to, as soon as you stop somebody, say, hey, I need you to get that mask off, because you need to identify who you're stopping. There's no ifs, ands, or buts about that. And once we've gotten to a stop, I think they should have that right. My concern with the language that was still on, which was the last 9 words that you would see on this amendment, the big concern I had there is I think you're opening up a lot of opportunities. Like a lot of us don't picture a circumstance where a law enforcement officer might approach you for no particular reason. I think it's still good if we have, and this is really for, in my opinion, protection of law enforcement officers during a very tense time, that we don't have officers feeling like that it's okay just to approach, Joe on the street and say, hey, I need you to remove that mask so I can make sure I know who it is that you are. And I don't think that's what we want. I think we want to balance their ability to enforce laws and to protect us and protect themselves with, a person's right to still kind of go on about their lives. The reason that we even have it in, and I commend the chair for being one of the first people to say, hey, we've got to get something in here about these masks based on the law that we already have. I thought that was great, is because there's going to be some natural tension about who gets approached with these masks, who gets talked to, things of that sort. And there will be a lot of times that is legitimate by a law enforcement officer. I just think that we ought to make sure that we've got some reason that we're approaching regular Joe on the street whenever we're asking them to remove their mask. And so I would ask that you support this amendment just for that reason. Because again, what this does basically, it says, if you've got any other time as a law enforcement officer that you're public, they're going to have to take this mask off. But if you don't have a reason that you need to interact with them, you can't just tell them to take their mask off. So thank you, Mr. Chair.
Further discussion or debate on the amendment sent forward by
Chairman, this is Representative Torbett for a question or debate.
Representative Torbett is recognized for a question or to debate the amendment.
Thank you, Mr. Chairman. And with all due respect to my colleague, Representative Reeves, what does this do in case there is civil unrest or insurrection or something when it comes to law enforcement? Would protesters, for example, be able to wear a mask and not remove the mask? I just don't understand the application in that circumstance. If someone could explain that to me, I'd be very appreciative.
I'll be happy to answer, or however you would like, Mr. Chair.
The gentleman from Chatham, Representative Reeves, is recognized.
And Representative Torbett, I think that's an excellent question, and that goes to my point. In that circumstance, the law enforcement officer has a reasonable suspicion some type of law is being broken. So at that point, you don't have a right to conceal your identity. That's the bottom line. And so if you're out and there's civil unrest or anything going on, and that law officer approaches you, there's a reason he or she is approaching you, and you've got to unmask. I don't think the law is unclear on that, in my opinion. And so that's what I'm saying, is that you've got so much leeway under the present law. Like, for instance, I don't know if you know, but I mean, right now as it stands, if there was no virus going on or anything like that, it also has every right to approach a person, to have conversations with a person. You can see somebody walking on the sidewalk in front of Jones Street. And if you're an officer and you decide you want to stop that person and have a conversation with them, there's not a law that stops you from doing that. Definitely, if you're involved in anything that might even be considered a crime or a precursor to a crime, you as an officer have a right to go to that person and say, hey, who are you and what's going on here? So this does not interfere with that right at all, in my opinion.
Mr. Chairman. Ms. Chair, it's Representative Stevens. I just want to see if I could weigh in for a minute.
The lady from Surrey is recognized to comment on the amendment.
Thank you. And I'm sort of going to respond to something that Representative Reeves just said. And he said if the officer has probable cause to think there's an issue, a reasonable suspicion. Okay, but I would think either, because it doesn't say anything about investigation or arrest. You see what I'm saying? It only says traffic stop, checkpoint, roadblock.
Which, if I may respond, Mr. Chair.
The gentleman from Chatham, Representative Reeves, is recognized.
And again, Representative Stevens, in my opinion, if we don't specifically address something in this bill, then that means that the law that already stands in place applies. So what we've said is, if you have a law enforcement officer at a stop, what we've said is we're giving express discussion right here. So there's no issue in mind, which I think is what law enforcement is concerned about, is getting express direction. That if it's a checkpoint or traffic stop, it's not even a discussion. But again, if they're in the midst of an investigation, there's nothing in this bill, which is the same with the rest of the mask law, that protects you. So for instance, if you're wearing a mask, look at some of these other exceptions. If you're wearing a mask for religious purposes, you don't have a right to keep that mask on if that officer is investigating a crime. None. I can tell you right then, I appreciate and I respect your religion, but you're going to have to take that mask off so I can figure out who you are. And all I'm saying is, why would we treat people in wearing masks for physical health any different? And we're not. I mean, they cannot have that right because we have not expressly given them this right. We have to expressly give them the right to keep that mask on during a time that there's an investigation for them to be able to do it. Otherwise, that's it, because what the court's always balancing is the privacy interest versus the interests of the public and the interests of the police officer in protecting the government and protecting the people. And generally, they're going to weigh out on that one, on the side of the police officer. So in my opinion, absolutely not do you have any right whatsoever to keep your mask on if a law enforcement officer is in the midst of an investigation. And the only way that we could stop that is if we expressly said, if you're in the midst of an investigation, you still can't make this person take their mask off.
Okay. Mr. Speaker, Mr. Chair, I just wanted to make one. I think the fact that we put some specific circumstances perhaps may leave out the point of investigative. It may be that you could only demand that they do it when there's actually an arrest going on. And I would maybe just defer to Susan Seitz on staff and see what she thinks. I'm not wanting them to be able to get it for any reason, but I do want officers to have, probable cause, reasonable suspicion, not just an approach, but I'm not so sure that we didn't leave that out.
The gentleman from Wayne, Representative Bell, is recognized for a question or a comment.
Thank you, Mr. Chairman, Representative Lewis. Members, this is another situation where we know no bill is perfect, but we do have Representative Alan McNeil, Representative Carson Smith, Representative Pricey Harrison have been working on this. Anything that's come, really, this is the most controversial thing that's come before our committee. It's taken a lot of work on, and as you can see, this is going to a situation where we're going to have another divisive vote. And what I would ask is if Representative Reeves would withdraw the amendment and work with Representative Harrison and Representative McNeil and Representative Smith to find some common ground here, because we know there's an issue here and we want to get it right. And we do have parties that are currently working on this, knowing that we have a lot of work to do. But that's, once again, it's up to the member. I just hate to see a task force bill put forward that we've all been working together on, finish with a decisive vote. But as my remarks, and Mr. Chairman, thank you.
And if I may,
Yeah.
Representative Reeves, the gentleman is recognized.
Chair, and majority, appreciate that. If I'm hearing correctly what I heard from Representative Stevens, be clear, I'm fine putting that language specifically in there. I'm not opposed to that. If I heard her correctly, what she's saying is, I don't want my officers stopped in an investigation. I want them to have that ability. If an officer's got any reason that they need to investigate or do something, I want them to have that opportunity. So if we want to add that language and we can agree that we can support that language, you know, I'm fine in the interest of time because we're getting on 2 hours. If I'm hearing you correctly, Sarah, Representative Stevens, and I think this also alludes to concern Representative Torbett, let's stick that language in there to specifically give them that right. And then if we can agree that everybody's good on that, I'm fine with sending it out.
So, Mr. Chair, I will see if, and I'm fine with Sarah. I've always been Sarah, but yeah, anyway. I'm fine with working on that. And what they want to know, I guess, is Representative Reeves, if you're willing to withdraw the amendment, and I will talk to, again, you're talking law enforcement officers, but we're also talking lawyers and legal issues. So if you withdraw it, then I'll try to help with them work on making that change.
Okay, and that sounds good. I just want to make sure I'm clear. What we want to do is I'll withdraw and we'll put specific language in the amendment so that they're basically so that if a law enforcement officer is in the midst of any type of investigation, they're going to be fine. And if everybody's good on that, we can add that on later. Is that correct?
Representative Stevens, the chair is going to treat that as a question to you or to Representative Bell, perhaps.
I'm fine with that, and I'll be happy to call if Carson Smith and or Alan McNeil are not on the conversation. I will call them when we're done with this meeting.
Okay, thanks. And Representative Torbett, thanks for your thumbs up, and I will withdraw the amendment. Thank you, everybody.
The gentleman, the amendment shall be returned to the gentleman. Is there, Representative Floyd, what purpose does the gentleman seek recognition?
Just as a question for Representative Reed as being a Monday morning quarterback, if the amendment that Representative Reed pointed out several times, there was 9 words that he wanted to strike. So just so that those individuals might see him on the street, let him know that it was 8 words that he wanted.
I got trained in Lee County schools, Representative Floyd. I didn't get good Cumberland County education, so we can't count past 8. Sorry about that.
Thank you, sir.
Members, is Representative Bell, the gentleman is recognized.
Thank you, Representative Lewis. And Representative Reeves and Representative Stevens, I would ask that when you include Representative McNeil and Representative Carson Smith that have been working on this, also include Representative Harrison. The 3 of them have been working throughout the process, our task force on this issue, and all 3 of them should be included. Thank you.
Members, is there further discussion or debate on House Bill 1043? If not, the gentleman from Wayne, Representative Bell, has moved that House Bill 1043 be reported unfavorably to the original bill, but that changes be incorporated into a proposed committee substitute as amended. Those changes be rolled into a new proposed committee substitute for authorization for staff to make any technical and conforming changes, and for our staff to also include the following bills into that new proposed committee substitute. House Bill 1034, small business emergency loans. House Bill 1039, the COVID-19 Response Act. The proposed committee substitute for House Bill 1035, Education Omnibus. The proposed committee substitute for House Bill 1037, the COVID-19 Healthcare Working Group. And House Bill 1038, the COVID-19 Healthcare Working Group bill. That motion is seconded by Representative Torbett of Gaston. Is there discussion or debate on the amendment? Seeing none, the question before the committee is the motion as previously stated by the chair and offered by the gentleman from Wayne. Those favoring the adoption of that motion will say aye.
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 Sorry there. Those opposed will say no. In the opinion of the chair, the ayes have it. The motion is adopted. Members, this concludes our work for today. The chair thanks the members who have been either in attendance in the room or on this call. Chair thanks the members of the public and of course the press who have listened in. And as always, sincere thanks to our staff for their hard work in completing our work today. There being no further business to come before this committee does stand adjourned. That was a long motion. Sean, just like a page long.